All right, welcome to my YouTube channel. We are still going to play a game today, but this one is no longer ABC, just like we played the other day. This one would be true or false. So I will say something and it will be like a principle in law. So you either say whether it is true or whether it is false. For example, if I say something like, if you buy somebody, the punishment is death. True or false? Of course, you know that is true. So you understand the rules of engagement. Now, I'll be asking up to about 30 questions. If you're able to get 20 over 30, you did a very good job. So when you answer, you just, anyone you get, you mark one. If you don't get, just don't worry. So anyone you get, you mark one, mark one, mark one. So that when you are done, you count all the ones you have marked and know how many you have gotten. So let's start. Number one, true or false? So I'll give you 5 seconds here. True or false? Ignorance of the law is a valid excuse for breaking it. False. Of course, you know that ignorance of the law is never an excuse. Now, number two, true or false? A person is presumed innocent until proven guilty. Of course, that is true. Section 36, subsection 5 of the Constitution said it, that every person is presumed innocent until proven otherwise. True or false? Every contract must be in writing to be legally enforceable. False. It is not must that your contract will be in writing before it is enforceable. There are oral contracts, there are implied contracts that are, deduced from the conduct of the parties. So it must not always be in writing. And so all these oral contracts and all these implied contracts can also still be enforceable, even though it is not in writing. Okay. True or false? A judge can be a witness in a case over which they are presiding. False. A judge cannot be a witness over a particular matter that he's presiding over. A lawyer can be a witness, but if a lawyer is a witness in a particular matter, that means he would not be the one conducting the proceeding. He will not be like a lawyer in the matter. So not to talk of a judge. If the judge witnesses it, the judge would not preside over that matter. If you want to call the judge as a witness, that means that particular matter would be treated before another judge, not that particular judge that witnessed the whole thing. So if that judge is coming as a witness, he is coming as a witness only. He would not be a witness to a particular matter that he is presiding over. I don't know if you understand. True or false? A crime can exist without both actus reus and mens rea. True. Yes, I know most of you are asking, how is it possible? You have the mental element and the physical element. Now, actus reus, there are some offenses that you don't need mens rea. They are called the strict liability offenses. So you can read about it. Strict liability offenses, they do not need guilty mind. They do not need mens rea for it to actually be established that you committed an offense. Okay, number 6. How many have you gotten now? We have done 5. Okay, number 6. True or false? The burden of proof in a criminal case generally rests on the prosecution. Of course, it is true. The burden of proof rests on the prosecution. Why? Because the guy is presumed innocent. You have to prove his guilt. Number 7. True or false? Hearsay evidence is always admissible in court. Of course, it is false. Hearsay evidence is not admissible in court. Check section 38 of the Evidence Act. Of course, there are some exceptions, but we are talking generally. As a general rule, it is not admissible. Then when you go into section 38, section 39 and all that, you would see the exceptions to the inadmissibility of hearsay evidence. 8. True or false? A minor can never enter into a valid contract. The answer is false. A minor can enter into a valid contract provided that the contract is a contract of what? Necessaries. Okay. So that's 8, yeah? 9, true or false, double jeopardy prevents a person from being tried twice for the same offense after acquittal. Should I even give you time for this one? The answer is true, because that is double jeopardy. It prevents you from being tried again when you have been, convicted or acquitted from that same offense. So that is autrefois acquit, or you say autrefois convict. So that's the Latin word. So you don't try somebody for the same offense again after the first one must have, ended, whether in conviction or in exculpation. So exculpation is when they don't convict you, yeah, when they acquit you. So conviction is when they've convicted you and they've sentenced you probably to prison or fine or anything. So you cannot come back and retry that person for that same offense unless the person commits another offense. So number 10, true or false, a confession obtained through torture is generally admissible in court. Of course, the answer is false. So when you say that you were tortured and before this particular confession was taken, what will the judge do? The judge will order a trial within trial. So if your objection is, I did not make this particular confession by my own voluntariness or by my own volition, what the court will do, in order to ascertain whether you made the confession by your own volition, will order a trial within trial. And that particular trial within the main trial would be to ascertain whether that particular confession was made voluntarily or involuntarily. Now, if it has been ascertained that it was made involuntarily, it will not be admissible to be thrown away. But if it is ascertained that it was made voluntarily, it will not be admissible. Admissible means it will be admitted. Okay. Number 11. How many have you gotten now? This is 10. Over 10. How many have you gotten? That's your own business. Number 11. True or false, equity developed to correct the rigidity of common law. True. Of course, we know that common law was very rigid, when it was developed by the itinerant judges of those years. So equity came through the Lord Chancellor, of course, the keeper of the king's conscience, to ameliorate most of the technicalities and rigidity that the common law posed. So most of the times, the common law made use of a writ system. And when we talk about the writ system in common law, you must have an adequate and non-defective writ for you to have a right to an action. And so when your writ is defective, of course, you don't have any right to an action. But equity came and said, why must it be that for somebody to actually have a right that should be enforceable, that you must have a particular writ and your writ should be, perfect? Why not just look at why the people are there in court than all those technical things? So, of course, equity came and tried to ameliorate most of the rigidity and technicalities of the common law. So that's the question. Okay, so number 12, true or false, every breach of contract is also a crime. Of course, false, because breach of contract is not an offense. What is an offense? Section 36, subsection 12, gave you a description of what an offense is. And what did he say? By paraphrasing, is when a particular act is being criminalized or it is being forbidden by a law, a written law, and the punishment thereof is prescribed by that written law. So that is when you say it's an offense. So there is no place that there was a punishment provided for a breach of contract. And so you cannot say that a breach of contract is an offense, it's a crime or something. So that is why if somebody is owing you, or if somebody has breached a contract that you have entered into, you cannot go and call the police because it does not fall within the duties of the police. Section 4 of the Police Act, it does not fall within the duties of the police. So you must have to just probably go to court and sue in civil capacity, sue the person that breached the contract and maybe ask for specific performance or damages. True or false, Parliament can make laws with retrospective effect in every circumstance. Of course, that is. Hey! Look, I'll give that as bonus because I've already shaken my head and I thought I was teaching. I didn't know I was actually playing the game. Okay, number 11 is actually false. the parliament cannot make laws that have retrospective effect. Yeah, so they cannot make a law. Maybe for example, now they want to wicked you, they will now arrest you. What did you do? Nothing. Maybe you were eating with left hand and they arrest you. It was not a crime when they arrested you, and they will now make a law later after they must have arrested you and say eating with left hand is punishable with 15 years imprisonment. And when they now make the law, they will now come and apply it to you that you have committed an offense. So that is a law that has a retrospective effect. Do you understand what I'm saying? So it is not, done. True or false, possession of stolen property may sometimes be evidence of theft. Of course, true. So it is now on you to prove that that you did not steal that thing. If you had received the stolen property, of course you should prove that you did not have the knowledge, or they are the ones to prove that you did not that you had knowledge. Of course, if they cannot prove that you had knowledge before purchasing that stolen property, you don't have knowledge. Okay, true or false, judges create legislation. False. Judges do not create legislation. Legislation is created by who? The legislature. So what judges might create is a judicial precedent or a judges made law when there is a lacuna or vacuum in the laws that the legislature have made. So the judges can fill up that lacuna by judicial precedents or judges made law. Do you understand? True or false? Number 16. A person may be liable in thought even if they had no intention to cause harm. Of course, it is true. So it's just like we have the strict liability offenses, we also have strict liability torts. So I think the rule in Rylands against Fletcher. So go and read the case of Rylands against Fletcher. When they say that anything that escapes from your land and causes a damage in another person's land, you will bear the cost. You are liable because you are supposed to have removed that thing from your land. Now, you did not have the intention to cause the problem in another person's land, but because that thing escaped, let's say it's a particular pipe that started escaping water into another person's land and it causes a flood there and it causes some damage, you will be liable. You did not have the intention before to do that, but it happened anyway. So strict liability tort. You don't need to have intention for that one to come into fruition. Okay, number 17. How many have you gotten? Number 17. True or false, consideration is an important element of most simple contracts. True. So consideration, of course, it's important because consideration is that notion of quid pro quo, this for that. So if there is no consideration, whatever it is that people are doing is just gratuitous. And of course, gratuitous promise is not enforceable. In fact, consideration is what makes that particular contract enforceable. It's like I'm talking too much. Number 18, true or false, the maxim, he who comes to equity must come with clean hands, is an equitable principle. This answer is even giving out the answer. If you feel this one, if you feel it, true. How many of you feel it? Because of course, equity is an equitable. When you see equity in the maxim, why is it not going to be an equitable principle? Okay, number 19, true or false, an accused person must prove their innocence beyond reasonable doubt. An accused person must prove their innocence beyond reasonable doubt. Of course, the answer is false. You don't need to prove your innocence. It is the burden of proof lies on the prosecution to prove that you committed the offense beyond reasonable doubt. They should prove beyond reasonable doubt. You do not have any business proving your innocence. It is when they now prove beyond reasonable doubt that the burden of proof will now shift to you, the defendant, to have a defense or to lay your defense bare based on what they have proven. Number 20. True or false, a search warrant is always required before any lawful search can take place. Of course, the answer is false. So when a police officer wants to search you, on you like this now. You are walking on the road here. You have a reasonable suspicion that you might be hiding some things and they want to search you. They need not get a warrant. They need not get a warrant. So most of you that used to say, police wants to search you, be like, here's a search warrant. It's not every time. It's only probably when they want to search your house. Yes, they need, of course, a search warrant. But when you are driving and they want to search your car, they want to search you, they want to search your bag, they do not need a search warrant. So it is not every time. So the answer is false. So number 21, true or false, a precedent from a higher court can bind a lower court. The answer is true, because judicial precedents, there's what we call the principle of stare decisis. The decision of the higher court binding or being binding to the decision of the lower court. Of course, of the same country, like of Nigeria, because a decision of a higher court in England, for example, is only persuasive. It's not binding on the lower courts in Nigeria. Number 22, true or false, defamation only applies to statements published in a newspaper. Of course, the answer is false. Defamation is general. If I'm talking now and I say something wrong or bad or, defamatory against somebody here that I'm talking now on this YouTube channel, it is a defamation and they can sue me for that. So that's why I'm very careful. Okay. Number 23, true or false, the law recognizes corporations as separate legal personalities. Of course, the answer is true. Companies are called artificial persons. They have their own separate legal personalities from the people there. So if I have a company and I enter into a contract with you with the company name, so it is the company that entered into that contract with you, not me. I did not enter into the contract with you, so you cannot sue me. You sue the company. So you say, am I not the owner of the company? Of course, I'm the owner of the company, but the company has its own legal personality. It has this capacity to be sued. It has this capacity to enter into contract. You cannot sue me. So, different personality. True or false, number 24. True or false, an offer and an invitation to treat mean exactly the same thing. The answer is what? False. So, invitation to treat is an invitation for you to make an offer. You understand? I'm selling this thing, it's placed on the shelf. It's not an offer. It's for you to come and make an offer that you want to buy one of them. So they're not the same. Number 25. True or false, there is usually no intention to enter legal relations for contracts between husband and wife living together. The answer is true. So intention to enter legal relations is not present in domestic and social engagements. So of course there are some exceptions which I would trust that you would read. True or false, volenti non fit injuria means a willing person cannot complain of an injury they freely accepted the risk of. The answer is true. So volenti non fit injuria, if you accept the risk, you go into the boxing ring. You cannot come out and say that they assaulted you. You are the one that entered there. You wore your gloves. It's just that you are not strong. That's why they beat you. And you cannot come out and sue the person that beat you because you accepted the risk by entering the ring, and you were beaten up. True or false, murder and manslaughter are exactly the same offense. Of course, the answer is false. The difference between murder and manslaughter usually is, kind of intention, because in murder, before something can be reduced from murder to manslaughter, of course, they should have looked at your intention and know that, okay, it was not really your intention actually that you wanted to kill this person. But of course, total removal of intention will, of course, exculpate you. But for example, we take provocation. Yes, you did it. You intentionally actually did it, but the intention was in the heat of passion. You understand? But so that is manslaughter. It's usually reduced from murder to manslaughter, and the punishments are different. So murder is, of course, death, capital punishment, while manslaughter is most probably life imprisonment, or depending on the discretion of the judge. So true or false, the rule in Fisher against Bell was based on the distinction between an offer and invitation to treat. Of course, that's the answer, true. Because when you look at invitation to treat, the difference between offer and invitation to treat, you look at the case of Fisher and Bale. You also look at the case of Bootcash Chemists or something like that against England Pharmaceutical Company, blah, 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 and all that. I think this Fisher and Bale was about flicker knife or something. Shall I read it? Number 30, which is the final one, finally. True or false, equity follows the law. If you fail this one, thunder will fire you. The answer is true. Equity always follows the law. Anyway, we've come to the end of this one. Take care of yourself and good night. Okay, maybe you are not sleeping now. Maybe when you be seeing this video, be in the morning. So good morning or good afternoon or good evening. In fact, bye-bye.